Hello, everyone. Thank you for watching or listening to our podcast today. I'm Marites Bott of Bott and Associates. Today's topic is estate planning and divorce. You might think, how do those two topics go together? Well, divorce is one of those things that can affect your estate plan, whether it's your own divorce that you've gone through, and how is that going to work when your assets go to your kids and maybe an ex spouse, but it also will affect your estate plan if maybe your kids or beneficiaries get divorced. Um, so I always kind of try to explain that when we do estate planning, we're thinking of other things besides just here's your money, little Johnny, and get you get the money and you go about your life. What if we can give the money to them and then protect it from a potential divorce settlement, right? And I'll give you a couple examples. So what I like to do in general is provide for each beneficiary some type of divorce protection. And we usually use what we call an access trust. So let's just say mom and dad are Bill and Mary, their kids are Susan and John. Um, John is one of those people that you're worried about that he might someday have some challenges in life and possibly a divorce because they're not sure how good their marriage is right now. So when we give John his share, so let's just say he's getting $500,000. When mom and dad have passed, he gets $500,000 and it's put into an access trust that he can access, but it stays in the John trust name. So what does that do? It allows John to be able to kind of protect that money and just in case, because what if him and his wife get a divorce a year later after receiving that inheritance? So, okay, mom and dad die. There could be two things that happen. John takes the inheritance and puts into the house because they want to pay off that house. And it's a jointly owned house typically. You pay off the house, now it's fully paid off. But then a year after that happens, his wife files for divorce. And now what happens to the proceeds that you just paid off when it came to that house? Now that the house is jointly owned, even though your inheritance paid for the balance of that mortgage, now that house has to be evenly distributed or divided between you in the divorce settlement. Um, that didn't have to happen that way, right? The second option, so that's one option that's typical of a couple. The second option is we put it in a trust, and instead of paying off that loan, perhaps the trust is kind of part owner of the house, right? And so the John trust is 50% owner, whatever that percentage that you're paying off. And then the balance is owned 50-50 by husband and wife, by John and his wife. When that happens a year later and his wife wants to file a divorce, then that 50% that was only in John's trust name is only John's. It can't be part of that divorce settlement where you're saying, what do we have collectively? What did we commingle together so that we have to divvy it up? Because it's inherited money, he's protected his money and saved it for him only, not necessarily to divide in a divorce settlement. So there's a big difference between option one, where he just put everything into the joint asset, and then option two, where his portion is still in his name in a trust. To be protected. And so, an example that I'll share with you is, so a few months ago we did an estate plan for a husband and wife, and they're a young couple, probably mid 30s. And sadly, her mom had passed away and left her some money, which is fine. She had ended up getting a good sum of an inheritance from her mom. She got $2.5 million. So they had called me to do an estate plan, and we're doing some planning, wills and trusts and things like that. And I felt the need to tell her at least that she has a choice. She could certainly keep her inheritance in a separate trust in her name only if she wants to do that. And the conversation, of course, took place when both of them are present. As you can imagine, it was a bit of an uncomfortable conversation because she's like, "Oh, of course not. No way. My husband, I trust him. We're together. this money should be jointly owned. So I said, okay, it's your choice. But I'm telling you, I'm giving you the option. So that's the difference is it's kind of an uncomfortable conversation because you want to say you love your husband, you trust your husband, but maybe in the back of her mind, she was like, well, maybe I should keep it in my name, right? It's her choice, it's her inheritance. Because if, say, a year from now, she signed her estate planning documents, a year from now, she comes to me and says, well, my husband asked for a divorce now. Now my money is going to be half his. Why didn't you tell me to keep it separate? I've given them the option, I've given them the choice. And she can't go back to me and say, I didn't know, right? You have to have that conversation, and it's a candid conversation. Now, if her mom would have created a trust that said, daughter, you're getting an inheritance of $2.5 million, but we're going to keep it in your name in a trust. So daughter trust as opposed to take that money and put it together with your husband. In that situation, then we wouldn't have had even the conversation because mom already made that decision for her. And it's not an uncomfortable conversation with her husband because yeah, mom already made this decision for me. She told me it has to be in a trust. And no offense to you, I'm just going to follow mom's instructions. So I always tell people it's sort of like an out for her because it has nothing to do with emotions or love or what you feel with your husband. It's not. It's just instructions by mom. When she wrote out her will or her trust, she said to keep it in the daughter's name in her trust so that way it's protected from any potential divorce in the future. So the moral of the story is plan early and plan and write it down because it is possible to protect your kids' inheritances from any future divorces, um, as long as it's done right, as long as it's in that situation of in a trust for the person who's receiving it. Um, on the flip side, another issue with divorce is when a person has passed and well, first of all, the person, husband and wife have gone through a divorce. Now they're, the divorce is final, but they didn't change beneficiaries on all of their 401k and life insurance. So I had a case a few years back where the woman called me and said, my husband, we got a divorce a year ago. He lived in Illinois here, but then he moved to Washington State, and then he unexpectedly dies. And then she tells me that she is the beneficiary of his life insurance at work and his 401k still. He didn't change it, which you should after a divorce. Um, so what ended up happening was an estate had to be opened in the state of Washington, and we had to work with that lawyer to make sure that my client gets a share because she's rightfully the owner or the beneficiary. The family of the husband, of course, was fighting tooth and nail and said, hey, wait a second, they're divorced. There's no way she should get it. But the way the law works, it depends on the state. I'm only speaking for Illinois. When you die in Illinois, whatever you wrote down in your beneficiary is what prevails, not what you wrote down in your will or your trust or verbal or anything that you've told people. If the beneficiary still has your ex wife on there, the money has to be paid out to your ex wife. So, just a word of caution when people go through divorce is write it down, change the beneficiaries, make sure that everything with your estate plan is basically matching your wishes based on the stuff that you just went through a divorce. We just don't want it to go accidentally to the wrong people. Okay. And then lastly, the one issue that the thing I talk about with divorce is when a couple is newly divorced and now one of the people is coming to me for estate planning, we talk about what is in the divorce decree. What are your requirements with the divorce decree? Do you have to keep life insurance up just so that, something happens to you unexpectedly? Do you have provisions for maintenance, right? Do we have to put that in the estate plan? Um, but really, I want to make sure that the money that you want to leave to your minor children doesn't accidentally go to your ex spouse and they end up spending it all without even benefiting the children. What does that mean? Well, in your estate plan, we want to put down these provisions that say, whatever I'm required to do in the divorce decree, maybe it's a life insurance policy, the proceeds have to be laid out and given to my kids in a trust. And somebody in my family will watch that money and make sure it goes to the kids, not necessarily directly to your ex spouse who might just grab it and go. Or maybe they're on their own, remarriage already. And then that money has gone to that other family and that person rather than your kids together. So, super important. It's when you're doing estate planning, it's not just so people mostly think they are like, oh, my life is simple. We'll just give it to the kids or spouse first, then to the kids. But what we do is kind of think through outside the box. What other issues will you or your beneficiaries possibly go through? And then we plan around those real life issues and make sure we write down what you wish to happen as opposed to it and the money going accidentally to the wrong people. That's the goal. And if you do have any questions and anything that maybe you already have an estate plan, you're not sure if it's protected from divorce with your kids, give us a call. We can certainly take a look at it and see what we can do and help you with. But we're here to help you in that regard. I can help to review documents as well as prepare, obviously, new documents if you haven't had one already. So, once again, thanks for watching or listening to our podcast. Hopefully, you learned a little something, and we will talk to you soon. Have a great day.